am oftentimes asked, or I hear stories of people saying, you want to avoid probate, you want to avoid probate. And I somewhat chuckle because it's very difficult to avoid probate. It's not as bad or as expensive as people make it out to seem, but that's why they go to professionals like you and trust in estates attorneys to get a determination as to what's the best thing for them to do from a financial perspective.
Are you ready for a successful retirement? We're addressing the topics facing today's retirees. Welcome to Retire with Ryan. Now here's your host, Ryan Morrissey.
Welcome back. This is episode 101. This week I'm joined by a special guest, Edward C. Burt Jr., probate judge and attorney in the state of Connecticut, otherwise known to his friends as Ned. Welcome, Ned.
Thank you very much, Ryan. I feel very honored to be here.
So this episode, we're going to talk about probate, and I've touched in the past about some general estate planning advice and guidelines. So today we're going to get more into the probate process, and who better to help us with that than a probate judge in the state of Connecticut. Now, tell our listeners, Ned, a little bit about yourself and your background with the probate court.
Well, I've been fortunate enough to be the probate court judge for Hamden and Bethany for coming on almost 9.5 years now. Both towns were served by wonderful gentlemen, Judge Yale and Judge Diglio, respectively, and then they combined all the probate courts down from 114 to 54. So I've been serving the Hamden community that I grew up in, and Bethany, which I've adopted, and they've adopted me. And it's really been a very enjoyable, interesting last almost 10 years.
Okay, awesome. So we were talking earlier about some of the matters that the probate courts in Connecticut handle. Talk a little bit about that if you could.
Sure. Most people associate probate court with decedents' estates. When someone passes away, family needs to button up the estate matters, the financial matters, any debts that may be outstanding that were owed by the deceased. And so they go through a process through the probate court in order to do that. But there are many other matters that probate court deals with, from adoptions, name changes, conservatorships, guardian matters, and on and on and on. We're blessed in this particular area, Ryan, with a New Haven Regional Children's Probate Court, which serves the communities of greater New Haven County from Orange and Milford out to Branford and the Shoreline. We deal strictly with children's matters as it pertains to probate issues, and that's a very specialized court. It's right across from Modern Pizza on State Street.
Okay. Yeah. I had no idea before you told me that existed. I guess I just honed in on the pizza maybe.
Yeah. Most people don't have a clue as to what probate court does or how do you deal with it, when do you deal with it. And unfortunately, oftentimes it's, as a result of a very sad situation in a family's life that they're dealing with us in one way, shape, or form. Sure.
Yeah. And as a lot of my listeners are nearing retirement, I thought today we you mentioned earlier, but talk about probating estates, kind of how that works. And I get the question a lot, from clients, how do I avoid probate, right? I think a lot of people have been taught you want to avoid probate if you can. So first off, is that even possible in Connecticut to avoid probate?
There are some trusts that you can establish that maybe skip generations with respect to taxes and things of that nature. But as far as filings and things that go by the boards, I am oftentimes asked, or I hear stories of people saying, you want to avoid probate, you want to avoid probate. And I somewhat chuckle because it's very difficult to avoid probate. It's not as bad or as expensive as people make it out to seem, but that's why they go to professionals like you and trust in estates attorneys to get a determination as to what's the best thing for them to do from a financial perspective.
Okay. So when someone loses a loved one, if they have some assets, I guess, part of that process is to open up probate potentially, right? And go through that process.
That's correct. And just so I don't forget to say this, one of the biggest things that many people are told, oftentimes by their lawyers, when you pass away and you have a survivorship interest in a piece of real estate, which oftentimes, obviously, married couples have, they're often told that they don't have to worry about probate because it's a joint asset, particularly with real estate. And the fact of the matter is, legally speaking, with a joint tenant with rights of survivorship real estate deed, when one spouse passes away, the other one automatically becomes the sole owner of that real estate. But there's what's known as inchoate taxes. So in other words, there may be an estate tax due to the state of Connecticut for that one spouse that passed away. It's unlikely, but that deed in and of itself is part of what needs to be probated for that remaining spouse to get what's known as a certificate of no tax due, which is placed on the land records. In my private practice with my wife, Chris, we do a number of things, but we also do a lot of real estate. And I can tell you that it's a very common situation where an elder person who's left standing may get into their late 80s or early 90s and they realize it's time to sell, or the adult children tell mom or dad it's time to sell. And a real estate title search gets done by the buyer's attorney maybe a week before the closing, and lo and behold, there's an issue because the spouse that passed away 20 years ago, the estate was not opened and filed to get that certificate releasing that potential lien. That can cause a delay in the closing. It can cause a real problem trying to resurrect an estate from 20 years ago. And it can also affect whether or not a deal goes through. So certainly, if anybody who is listening to this broadcast doesn't do anything else, they realize that just because a piece of real estate's in survivorship does not mean that it does not have to be probated. But I guess there's two questions with respect to probate when somebody passes away. Do they have a last will and testament, or do they not have a last will and testament? And candidly, in my experience, it's much better for someone to go to an attorney and have a will done. Most people at early stage in their lives or early stage in their marriage, what's considered a simple will should suffice. Obviously, if there's significant assets, that's a different story. And as you get older, you obviously have to deal with elder law issues and more sophisticated trust and estate issues, which I know you deal with.
Yeah, no, you raise a good point. So going back to what you were talking about with the real estate, I've heard that too, that a lot of times when the first spouse passes, they're told or they think they don't need probate, because if most of the assets had beneficiaries, if they had joint bank accounts, they could easily get those things moved over into their name. It's really, like you said, when they then are trying to sell their real estate, that now problems arise because the invisible hand of Connecticut is in their pocket and they don't even know it. And now I've seen it costs a lot of money to go back, like you said, and open an estate from 20 years ago, and they have to reopen that. And then if the parent passes away, now they're dealing with two estates, right? Because they've got to reopen the old one and then do the current one.
I'm glad you said that, because a friend of mine called me just last week, and that's exactly the scenario he's in, where the second spouse passed away before either estate was taken care of. And now, obviously, they've got to backtrack and do both. And, sometimes you run into a situation where no family member wants to get involved in that. And so you're hiring a professional from the get-go, not only to open up the estate and do the estate, but perhaps to serve as an administrator or a fiduciary in one way, shape, or form. So it makes good sense to spend the time to go to an attorney, get a last will and testament in place. And as far as real estate, yeah, I can't tell you how many lawyers that do real estate. I can't tell you how many real estate agents who know what they're doing. I don't know why it slips by the boards so often, but it does. And people need to be aware of that for their own sake.
Yeah, to be able to sell that property down the road, right?
Absolutely, positively.
So let's say you didn't do that and, you've got to reopen probate for someone. How long does that process take, or can that take?
Typically in that scenario, it shouldn't take too long. Most likely, as you indicated they're going to have all their other assets either in survivorship or they're going to have designated beneficiaries. So hopefully it's not that intrusive. It can be, but there are different ways also to make that process move forward. If you're dealing with another experienced real estate attorney and you have a title insurance company that's willing to allow a transaction to go forward with, a certain sum held from the closing, but it can definitely cause problems, no doubt.
Okay. So sometimes I guess the transaction might go through, but there's a lot of variables involved in that.
As so often is the case, as you know, when you're dealing with these types of things, what appears to be simple ends up being more complicated, and certainly the delay in not doing it properly from the get-go. And it's, lots of people are told you don't have to do it. And so what are you supposed to do? You're talking to somebody who you've talked to for 20 years who's represented you, and they're telling you you don't have to do it. It's in survivorship and c'est la vie. And then it goes the other way.
Sure. Yeah. So when someone does open up probate, they have the option, I guess, to do it themselves or to use a professional, right? Do you have any idea of like what you see? Do you see like majority of people using an attorney or majority not? Like,
it's a mixed bag depending upon what's involved. Most people, when they're processing an estate, use an attorney. And honestly, it makes the most sense to me for someone to use an attorney. Does it cost money? Of course it does. But the process itself, it's just like anything else. And I tell people this all the time. You're in your profession because you know what you're doing and you do it well, and you can do it well and you can explain things to people. When you're not used to something, it's easy for someone like me to say, oh, that's going to be a simple estate. You can do it yourself. Yeah, you can do it yourself, but there are certain timeframes you have to do things by. There are certain things that need to be filed in a timely fashion in order to process things and not to have you incur penalties. So the stress involved, especially when you've lost a loved one, it just seems to me to make much more sense to hire the professional, spend the money on a professional, and have it done.
Sure. So you talk about time frames. Is there a time frame in Connecticut that you have to send your estate through probate?
Yeah, there's a whole laundry list of time frames, Ryan, with respect to an estate. There's also two different kinds of estates that I just want to backtrack a bit with respect to. If someone has a last will and testament, that's a testate estate. So it's all laid out as to where they want assets to go, how they want debts paid, who they've appointed as an executor or an executrix. And then there's intestate estates, which have no will. And that becomes a little more cumbersome for people to handle. But typically with your regular estate, if someone has the last will and testament, they're supposed to file it within 30 days of the decedent's death. And then typically there's a form, it's a PC 200 form, which is probably the only numbered form I know. But that's what people file to open up an estate. So if you had a last will and testament and somebody had passed away and you were either named in the will as the executor or executrix, you would be the one filing that with probate. And then there'd be a hearing held in approximately 14 to 30 days after some notice was published in the newspaper regarding it. And the newspaper notice is simply so if someone wants to contest it and they don't feel that the person was either of sound mind or that there was some undue influence, they could come into probate court and challenge the will itself or challenge who is to be appointed as the executor. And I'm using that term. I mean, you're familiar with it and you're familiar with the term fiduciary, but basically an executor is the person who's been named in the will to take care of channeling the entire estate process through probate. The executor is a male, executrix is a female. If you don't have a last will and testament and you file, you ask for an administrator or administratrix, but they serve the same role.
Would that be a legal professional if you didn't name someone as your executor or executrix?
It does not have to be a legal professional who serves in that capacity. You certainly could have someone serve in that capacity. It probably would make more economic sense if you have a family member who you trust. Oftentimes a spouse will name a spouse. And then if they have an adult child who's around and responsible, they'll name that adult child as the alternate. You don't need certainly an attorney to serve in that role. I mean, unless you're dealing with a very sophisticated estate or a very economically lucrative estate, you certainly don't need it.
Okay. So, I mean, I guess from a financial standpoint, the attorney is going to charge you probably something, right? It's expected, right? That's their profession. Your friend or family member most likely wouldn't, but could they? I've often heard that they could if they wanted to, right?
Yeah, they can seek reasonable compensation from the probate court for their services. And quite frankly, many of them deserve it. Most of them do not ask for it, but many of them deserve it. Where you run into issues oftentimes is when a lay person has been appointed as the fiduciary and is entitled to a reasonable value of services, and you pegged a number, whether you're going to give someone $25 an hour or you're going to give somebody $50 an hour, or whether you're going to give somebody 2% of the gross estate or 4% of a gross estate. Where you run into a problem is where an administrator gets appointed and they claim that they spent 30 hours cleaning out the house and that they want to be compensated at their administrative level, as opposed to being able to call someone that would come clean out the house for $500 or $1,000, and they're asking you for $10,000 or $8,000 or things of that nature. That makes it more interesting.
Yeah, I could imagine. And I'd imagine too that when it could create some interesting family dynamics, right? If there's multiple siblings and one is the executor and all of a sudden they're asking for a large amount of the estate for their work and the other siblings don't agree or something, right?
Absolutely, positively. We run into that more often than I wish we did in some matters, where somebody's, first off, they're upset that mommy or daddy named sister or brother as the executor, and then they're upset with respect to the distribution and they're questioning everything the executor or executrix does.
Yes, I can imagine that can be a difficult situation. Well, Ned, I think this is a great place for us to stop for this week. We have some more to discuss. Please remember to tune in next week for part 2 of my discussion with Ned, where we continue talking about probate and how to simplify the probate process. Also, if you're enjoying these podcasts and you haven't already done so, I would greatly appreciate you leaving a review on Apple Podcast, or if you're listening to it on another platform, I would appreciate you subscribing. Have a great week, and I look forward to talking with you next Wednesday. Take care.
You should consult a financial advisor familiar with your specific circumstances before you make any financial decisions. Nothing in this broadcast constitutes a solicitation for the sale or purchase of any securities. Any mention of rates of return are historical or hypothetical in nature and are not a guarantee of future returns. Ryan Morrissey, CFP, is an investment advisor representative of Morrissey Wealth Management, LLC, a registered investment advisor.